Okay, we are live. All right, everybody. Today we have with us Amelia Arutunian. I'm going to briefly introduce her. Amelia Mila Arutunian is a partner at Gomez Trial Attorneys and the director of the firm's Labor and Employment Group. Before joining Gomez Trial Attorneys, Mila spent her career litigating cases on the defense side, including defending California businesses against claims and lawsuits involving workplace harassment, discrimination, and retaliation. After being exposed to challenges employees suffered in the modern workplace, Mila left the defense world to pursue her passion in representing the people and bringing lawsuits to help employees who have been wronged by their employers and suffered emotional or financial losses as a result of the same. Mila has been named Best Lawyers, Ones to Watch in Labor and Employment Litigation in 2021 and 2022, and Best Lawyers Women in the Law in 2023. She was also selected as a finalist for the San Diego Business Journal's Leaders in the Law Awards in 2021. She was named Attorney of the Month by California Attorney Journal in March 2023. She's currently the president of the San Diego County Bar Association Employment Law Division, a co-chair of Lawyers Club of San Diego Life and Law and Parenting Committee, and on the executive board of the Women Leaders of Gomez Trial Attorneys. She's also a mother of 2 boys. She has a lot going on. So with that, thank you for being with us today, Mila.
Thank you for having me.
Yeah, absolutely. So, to begin, I kind of have a question, and that is, why the transition? I mean, can you kind of explain that to us a little bit?
Yeah, sure. A lot of people ask me that, and I'll tell you, I spent most of my career, almost a decade, representing defendants when they were sued. And coming up in that culture, I always thought I was doing God's work, and I was, it was black and white, and I was representing the good guys, and the plaintiffs were the bad guys. That's how I was conditioned from day one. And as my career progressed, I realized that there are gray areas. It's really not black or white. There isn't a good side or a bad side. And laws exist for a reason, to protect people. Eventually, I realized that honestly, there were cases that came in that I just didn't feel very comfortable in defending. And so when John Gomez came to me and said he wanted to open a labor and employment group, and asked me to run it, initially I really thought it through, and I decided I would feel more comfortable representing people. Transitioning initially was kind of confusing for me because I had to do a whole mental transition from, being very defense minded to plaintiff minded. Although it's the same legal industry, it's very different sides of the coin. But as time has gone on, I couldn't be happier with my decision. I really feel like this is the side that I belong on. And then, kind of as an added bonus, my son is now understanding what I'm doing. He's 6, and he really loves to tell people that his mom helps people when they're bullied at work.
Yeah, that's awesome.
Yeah.
Yeah.
I'm very happy with my decision.
That's great. That's really good. So, we're going to hit a couple topics today, everybody, and about employee rights. And we're going to start with, we hear a lot about at-will employment. So what does that exactly mean?
Sure. So technically, California is an at-will employment state. And a lot of people think this means, oh, well, that means an employer can terminate you at will for no reason at all. Technically, yes. Generally, an at-will employment relationship, either the employer or the employee can terminate the agreement at any time for any legal reason, with or without cause. But the caveat there is that the reason for termination has to be legal. So even with an at-will employment, if you can show that the reason for termination was actually discriminatory or retaliatory, then it becomes a lawsuit.
Okay. And we're going to talk about those in a little bit. Well, might as well start with the discrimination aspect of things. So, what does it mean to, legally speaking, for somebody to be discriminated when they got terminated?
So anti-discrimination laws apply in the context of termination, but also generally throughout the employment. So most of these laws apply to employers with 5 or more employees. There are protections both under California law and under the federal guidelines. California law is unsurprisingly a lot more protective than federal law. But generally, the law states that employers may not discriminate against employees or job applicants. So this also applies to people who are applying to jobs. Because of a protected category, and there are protected categories listed, and we can talk about those. And they cannot retaliate against them because they have asserted their rights under the law. Illegal discrimination occurs when at any time an employer treats an employee differently because of the protected category. And these laws apply to all business practices. So this applies in the application process, during screening and interviews, for participation in a training or apprenticeship program, hiring, transferring, promoting, or separating employees, working conditions, compensation, even advertisements. Basically, employers have to treat all employees the same, regardless of whatever class that they're in.
Oh, wow. Yeah, it sounds like it's pretty broad.
Very broad.
As far as what it covers. So you did mention there's like certain protected categories. Like, do you mind just sharing with us and the audience what those protected categories are?
Sure. So since we're in California, we can talk about California laws. California protects more categories than the federal guidelines, but generally they're very similar. The protected categories under California law are race and color, ancestry or national origin, religion or creed, age, and the age status is 40 years and older. So if you're 40 years and older, you cannot be treated differently than younger employees. Oh, wow. I personally feel like the age should go up a little because 40 is still pretty young. Yeah. California thinks 40 is like getting up there. So any mental or physical disabilities, these include mental disabilities, even learning disabilities. So sex and gender, including pregnancy, childbirth, or breastfeeding. The breastfeeding laws actually were not as inclusive under federal guidelines until very recently. But now the federal guidelines are starting to become more in tune with California law. And then sexual orientation, gender identity or gender expression, medical condition, genetic information, marital status, or military or veteran status. So anytime an employer treats any employee differently based on any of these statuses, and it could be something very just very vague. For example, there were cases when, an attorney, for example, there was a female attorney and a male attorney, and the boss would always give the male attorney more of the bigger projects because the female attorney had kids at home, right? And the boss didn't want the female attorney to have to work late because she needed to go home to her kids. Well, guess what? Because the male attorney got more of those bigger projects, he got more chances at promotions and being noticed and recognized and probably pay raises. So that even something as innocent as that had very good intentions behind it is discriminatory. That would be discriminatory on the basis of gender as well as having kids. So little things like that you wouldn't even notice, but they could constitute discrimination.
Wow. So we talked about the protected categories under California law. Now, you, I think, uh, also mentioned at the time of termination that they can't be retaliated against. Like, first, like, what does that exactly mean in that setting? Or what examples have you seen about it?
Yeah, that's a great question, because retaliation does sound broad.
Yeah.
So anytime any employee complains about anything, any unlawful conduct in the workplace, and an employer takes any adverse action against them because of the complaint, that constitutes retaliation. That can be an adverse employment action, could be anything that negatively affects your employment. So the employer doesn't even have to terminate the person. They could change their shift to something that's undesirable to them. They could change their salary or give them less hours. They could change their boss if the boss is someone that they don't get along with. Anything that really affects, and there's case law on this that looks into what is considered an adverse employment action, but it's basically anything that substantially affects their work. And so anytime you make any complaint in the workplace, that can be any complaint of of any illegal activity. To say my boss is bullying me, and technically that's a harassment complaint, right? It may not sound like it, but it is. And all of a sudden they change your shift, and they change your shifts in a way that don't fit with your schedule, or they put you on a different shift, or they cut your hours. And it could be that in their eyes they're trying to help you, but if it substantially affects your job, that could be a retaliatory action. So exercising your legal rights may include submitting a harassment complaint, complaining, even participating in an investigation. So if someone else submits an investigation against someone and you choose to participate in that investigation, and then your employer does something that adversely affects your terms of employment, that can be considered retaliation. It could be reporting a safety code violation, reporting fraudulent activity. It could even be taking a family leave for a pregnancy or childbirth. So like if you take a leave of absence because you're having a baby and you come back and the cases that you had are given to another associate, right? And your boss is like, well, the client really likes this person better, so we're gonna have them stay on these cases. That could be retaliatory, right? Because it could substantially affect your position, especially if that client was critical for your partnership within the firm. And then just some examples. I know we kind of went over this, but adverse employment actions could include salary deductions, demotions. It could even be something like exclusion from staff meetings or benefits. Unjust negative performance reviews could be adverse employment actions. Denial of promotion, if you can prove that the denial, like you were qualified for that promotion, as qualified as someone else, and they denied you because of a complaint you made. Or if the employer creates a hostile work environment that forces you to quit.
So, like, let's touch upon that you know, the hostile work environment,
Sure.
because you just brought it up while we're on it. What does that exactly entail? Like, what are some examples of hostile work environment?
So a hostile work environment is basically workplace bullying that is severe enough to create a legal cause of action. It's usually created by harassment, and it's based on any protected characteristic. But it has to be severe or pervasive enough that an employee reasonably believes the work environment to be abusive. So when courts look at this, or when judges look at this, they look at different factors to determine if a hostile work environment has been created. They look at the frequency of the conduct. So if something happens one time, someone looks at you wrong one time or says something to you one time, I mean, depending on what is said, obviously. But if something happens to you one time, probably not a hostile work environment. So frequency, and then the severity of the conduct. how severe was it in the eyes of a reasonable person in that employee's shoes. And then whether the conduct is physically threatening is taken into account, whether it's humiliating, or if it's merely offensive. Like if it's just something that may be offensive, but it's not really humiliating, probably wouldn't meet the criteria of a hostile work environment under the law. And then the court also looks at whether the conduct unreasonably interferes with an employee's work performance. So if their performance starts failing and they show that, well, this conduct was occurring that caused my performance to decline, the court takes that into account when determining whether a work environment was hostile. And a lot of times the hostile work environment depends on the context of any given workplace and the specific facts of each situation. What that means is they'll look at what type of workplace were you in? Were you at a law firm that was expected to be professional? Or were you at a construction site that's a little more laid back? And so in determining whether or not the work environment is hostile, that is also taken into account. The context, the type of business that you're in, and what is normal in that realm.
Wow. It sounds like a lot goes into it for the courts to determine what's going on. Something just came to my mind. Is the duration of that like a factor too? Like for how long it went on?
Definitely.
Like in other words, I mean, okay, so that's one other factor. Okay.
And I think that goes into like the pervasiveness.
Got it.
How long, how frequent, how pervasive was it? And then again, all of this would be taken in the context of a reasonable employee in that person's shoes. So
Okay.
if a person is, claims that they're highly offended, but a reasonable person may not be, if a court or a judge finds that a reasonable person would probably not be offended by those actions, usually hostile work environment doesn't fly.
And so like if somebody wants to like know whether or not they've been wrongfully terminated, like what do you look at, or what should they look at?
Yes. So we get a lot of calls. I mean, most people who are terminated don't think that it was for a good cause. And that's normal. Like our jobs are a huge part of who we are. Inevitably, we spend a lot of time at work. No one wants to be fired. The main thing is you have to look at, was there an unlawful reason? Like, was it discriminatory? Was it in retaliation for a complaint that you made? And was that a substantial motivating factor for the termination? So what this means is that even if there is discrimination or retaliation that went on in the workplace, okay, and you can prove this, but there were mass layoffs and 70% of the company was laid off. And this particular employee was part of the layoff, but he had some discrimination against him. But if the company can prove that they would have terminated him anyway, then you lose the wrongful termination claim. You may still have the discrimination or retaliation or whatever underlying issues that happen, but if you cannot prove that that was a substantial motivating factor in the actual termination, then wrongful term is out.
Right.
So unlawful termination may occur when an employee is terminated because of their membership in a protected class, and those are the classes we talked about. If someone is a woman or African American, and let's say the employer kept all the men but terminated only women, and we can prove that because she was a woman that was a substantial motivating factor for the termination, then we could have an unlawful termination claim. Unlawful termination could happen if an employee refuses to commit an unlawful act. If they exercise their legal rights, like for example, filing a workers' compensation claim. After filing a workers' compensation claim, they're terminated. And we can establish that the termination was a result of the workers' compensation claim, or that was a substantial motivating factor of the termination. That can be wrongful termination. Reporting wage theft. What we talked about previously, if they choose to participate in an investigation, they have that right. If they're terminated because of it, that is a wrongful termination. If they take protected leave under either the federal guidelines or the California guidelines, or if they take protected sick leave, those can all constitute wrongful termination. So again, as long as there was an unlawful reason that was a substantial motivating factor for the termination, that is considered wrongful or illegal termination. And let me say one more thing.
Sure.
So wrongful termination can be when someone is terminated, or wrongful termination can also occur when someone is constructively discharged. So an employee doesn't have to actually be physically terminated for there to be a wrongful termination claim. There's also a constructive termination claim, which is when the employer basically makes a work environment so hostile and so unbearable that a reasonable employee would have felt that they had no other choice but to quit. Then that would also constitute, it's technically a constructive discharge, but it's basically very similar causes of action.
Okay. So, all right. So this could be sort of like implied in the conduct that was being done.
And I often get those calls. I mean, I just had an individual call us, and she was just like, I was harassed, I made complaints, nothing was done to address them. Her supervisor just was very inappropriate with her sexually. She made complaints to HR. It was a small company. They didn't really do much to address it. They basically ignored it, and she just couldn't be around him. She was very traumatized by it, and she just couldn't fathom going back, because every time she went back, she would get these comments. She was like, I quit. I didn't know what else to do.
Right.
Do I still have a claim even though I voluntarily quit? And I would say in a case like that, especially if you can prove that you made these complaints to HR and they didn't do their duty to protect you, absolutely you have a constructive termination claim.
Got it. So it sounds like in her situation, at least, like she tried to basically exhaust everything like internally, and if they kind of blew her off, then it's like, what am I supposed to do? Like, my employer's not helping with my...
And that is the one thing that I will say too. The employer has to be aware that these things are happening.
Right.
If an employee does not complain to either a supervisor or HR, and there are no real witnesses to any of the things that are happening, they can't then quit and say, well, it was a hostile work environment. The employer didn't have an opportunity to even try to protect the employee in that situation.
Right.
They really have no duty to act. And in that case, there wouldn't be a constructive termination claim.
Yeah, makes sense. Okay. So I think you touched upon a little bit on sexual harassment as a bit of a moving on to a different area, I suppose. So what is sexual harassment in the workplace?
So sexual harassment in the workplace is negative, inappropriate, or unwanted conduct directed at an employee because of their sex and gender. California law protects against a broad range of behaviors that can constitute sexual harassment. These can range from conditioning employment benefits on tolerance of unwelcome sexual advances to the creation of sex-based hostile work environment. It can really be anything that has to do with sex, and it doesn't even have to be that aggressive. It can be comments or anything like that.
Right. So it sounds like, again, it covers a lot. It's pretty broad for the right reasons. They're trying to protect people in the workplace. Okay. So, on that point, like what type of acts are required for a viable sexual harassment claim in the workplace?
Really, any action that has to do with unwanted advancements or anything that has to do with treating an employee differently because of sex. Sexual harassment does not require sexual acts or touching In fact, sexually harassing conduct does not need to be motivated by sexual desire at all. California sexual harassment laws protect employees against any kind of harassment based on sex, gender, pregnancy, childbirth, or related medical condition. And this can range from anything from sexually explicit discussion or content in the workplace to pervasive sexual favoritism. So the example we talked about before, where the male associate was given more of the bigger projects or the better projects because he didn't have to go home to his kids at night and could work longer. That can be sexual harassment. Anytime when you treat a male better than a woman, that can be sexual harassment. And then, of course, you have those really you have levels, and then you have like the sexual commentary if you make comments, and then you have touching, and that goes in hand with criminal law. Like I always advise clients if their supervisor touched them, made unwanted sexual advances, and that's assault and battery at that point, and they should file a criminal complaint and get a restraining order.
Right. It seems like it covers a very, very broad spectrum of acts, and it doesn't even have to be touching. It sounds like it just. I never thought that it's like I don't know anything about it. I'm learning a lot from you actually. So it seems like it's very, very broad. I think we touched upon this one, the hostile work environment. Do you want to kind of give us a little bit more information about what constitutes, and what constitutes the work environment becoming hostile?
Yeah. So basically, I think we touched about most of it, that they look at the frequency of the conduct, the severity of the conduct, how pervasive it is, how long it's ongoing, and whether the conduct unreasonably interferes with an employee's work performance. And a hostile work environment could be sexual harassment. It could be that someone is, a male is being treated better than a female, or is given preferential treatment. If it's regular and ongoing, that could constitute a hostile work environment as well.
And so, we've touched on a lot of topics and a lot of information. What would be your best advice to employees when experiencing either harassment or discrimination in the workplace?
Yeah, we touched on a lot of topics and it went pretty quick. It went quicker than I anticipated, right?
Yeah, it did. It's a lot of information though. So a lot of good information. Yeah.
So my main thing and honestly, even when I was representing employers, I would say people would bring a case to me and I would say, I wish I was part of this before this turned into litigation, because I am a litigator, so I normally get the cases when it's too late to do anything. But a huge part of my job, I feel like, and my duty, is to make sure that people know their rights, right? They know their rights. And the problem that I've seen again and again, because I often get leads where people are calling and they're currently undergoing these issues. They're like, my supervisor is harassing me, my boss is bullying me, my coworker is touching me, and they don't know what to do because they don't know what rights they have, and no one wants to lose their job. Everyone's comfortable, and they think they don't want to go to HR. They don't want to go to their supervisor when these things happen, especially like for women, it's very uncomfortable, but men too, right? And I've even had situations where it was male on male, and that sometimes could be even worse, or female on female sexual harassment. Because then it's just like awkward, especially like with males. Sometimes you have like your masculinity and pride, and you don't really want to admit that this is ongoing, but it's uncomfortable. It's uncomfortable regardless of what gender you are, regardless of how strong you are. No one wants to be in a position where someone above them or superior to them is treating you badly, whether it's sexual or otherwise. And I always tell them, did you document it? Number one, did you document it? That's like the most important thing. And I gave the same advice both to my employer clients, to my employee clients. If you do not document something, it did not happen. I had the same issue when I was defending employers when they would fire people and they were like, well, they had all these performance issues. And I was like, okay, were they documented? Because if they were not, you're not going to be able to prove it. Same with this.
Right.
An employer has all of these duties to protect their employees, right? California law has set up the most beautiful system to protect employees. Like, there is no better state for this, no better country for this. We literally have the most overbroad laws to protect employees than any other place in the world, probably, right? But an employer does not have any duties to the employee if they are not aware of what's going on. And as uncomfortable as it is, as much as we have to get out of our comfort zone to face these things that are happening, my biggest advice to everyone is, if something is happening, document it. And I always, I love my job, but I know at the end of the day, I'm still an employee, as is everyone else. So, people take it personally. It's not personal. And you shouldn't feel sorry or scared or intimidated for standing up for your own rights.
Right.
We spend so much time at work. Like, the 8 to 5 day is gone in 90% of professions. And you should feel comfortable and safe within your workplace. And if you don't, then you need to change that. And then I have cases that come in all the time where, like, they're right up against the statute of limitations. And I'm like, why did you wait 2 years? And the person's like, I just really didn't feel comfortable addressing this. It's embarrassing, right? Like, it's embarrassing when you're bullied as an adult and, like, treated badly and you leave, and it's easier to just shut your mouth and be quiet. Or if you're harassed, and it's easier to shut your mouth and be quiet. But the problem is that these employers will keep doing this.
Right.
Companies will keep doing it, or whether it's sometimes it's supervisors. They'll keep doing it. So you have to document. You have to inform HR or a supervisor if something is happening that is wrong or illegal. You're treated badly. You're treated differently. If you don't want to do it for yourself, you should do it for the people who are around you or with you. Like, speak up. And I learned about this in a lot of, like, women's seminars, because women suck at speaking up for themselves. I feel like men are generally better at it than us, but men often share the same issue. Even as attorneys, we fight for other people for a living.
Right.
But when it comes to standing up for ourselves, we're like, oh, no, it's okay. Don't worry about it.
Yeah.
That's not okay. That's not okay. You have to stand up for your rights. That is what the laws are made for, to protect employees.
Right.
So that was a very long spiel, but I'm, like, so passionate about it.
No, I can see that. And I think, like, I have, like, one other thing that comes to my mind, which is, like, I feel like a lot of employees also, they're, like, afraid because they're like, oh, well, if I sue my employer, like, maybe the next person's not, I'm not going to have a job ever, or something along those lines. Is there any way to, like, sort of lessen that fear of theirs, as far, you know what I'm saying?
I get this a lot. I get this, a lot of people call me. So I'll tell you one thing, Omid. You'll understand as an attorney. I don't know if consumers will fully understand this. Employment law, unlike a lot of other fields of law, has a cost shifting provision. With, like, it's statutory, which means that if an employee, I mean, this is generally speaking, obviously there are exceptions to this, but generally, if an employee brings claims for 20 causes of action and they win one, they get all their attorney's fees.
Right.
The jury verdict could be $20, but I'll get all my attorney's fees. So I have no incentive to settle early if I have any validity to my claim on the plaintiff side. The defense side has the incentive to settle and settle quickly if they are legitimate claims. So generally speaking, most employment cases we'll have a long pre-litigation process before anything is even on file, right? So
Understood.
what we do, we send a letter of representation, we request personnel files, and we create a demand, a pre-litigation demand with our claims. Like, why do we feel our employee was wrong? We look at the personnel file to make sure, our client is being truthful with us and make sure there's nothing that, because, there are people who, they have performance issues that they don't necessarily tell us about. And we get that in the performance review. And like, obviously, if it's not a valid case, we're not going to take it.
Sure.
But if it is a valid case, we'll put together a demand with our facts and what we think our causes of action may be, and we invite the other side to participate in pre-litigation negotiations, whether that's informally through discussions or going to mediation. And more times than not, people will want to do that because an employer doesn't want to deal with a lawsuit. And an employer knows if they screwed up, they better settle quickly and cheaply rather than dragging the case out, paying their attorney's fees. And even if they go to trial and lose on one cause of action, they'll be paying our attorney's fees too. Even if the plaintiff is only entitled to $100 or $20 or whatever, So what I tell my clients, at least how I run my business, and I don't know if probably not every firm runs this way, but to me, like, my clients are always right. I would never push my client to do something that they're not comfortable with. So if they feel that they go through the pre-litigation process, the employer doesn't want to pay anything, and they're like, I really don't feel comfortable filing a lawsuit because I don't want this on public record, we're not going to do it.
Right.
Okay, we don't charge them anything.
Right.
They're the ones going through it. A lawsuit is a lot on a person mentally, physically. You have to relive like really traumatic things that, when people lose their jobs, it's always traumatic.
Right.
So we would never push a person to file a lawsuit that goes on public record if they don't have to. In terms of references, that part is a little tricky. But generally, regardless of whether or not a lawsuit is filed, if you've been terminated, you're not going to have a great reference anyway, right?
Right.
So even if a case goes into pre-litigation and they're worried about references, that's something that's just like kind of in the gray area. But I'll tell you one thing. Whenever we do settle a case, no matter how big or small the settlement is, we insist, non-negotiable, that they include a neutral reference clause in the settlement agreement. This means that if a subsequent employer calls the former employer and tries to get a reference, they cannot say anything about the lawsuit. They can't say anything about the case. All they can say is that the person did in fact work there and the dates that they worked there. And they cannot give, pursuant to the settlement agreement that they are forced to sign, they cannot say anything else about the litigation or pre-litigation process or the settlement.
Okay, well, so that's good. I had sort of two other things that came to my mind. The first thing is we didn't. I mean, this might be maybe basic, but in these cases, like, what are the employees' remedies, so to speak, right? Like, I know, like, in the injury world, at least, they can get pain and suffering, they get past and future, and et cetera, lost wages, et cetera. So what is that in the employment setting? And I don't know, I mean, maybe some of them are different as far as remedies are concerned, but if you can answer that.
No, that's a great question. So we look at both economic damages and non-economic damages. The economic damages would be lost wages. So whether you're terminated or you're constructively terminated, you are eligible to receive lost wages. But here's the caveat. You can't just sit and say, I'm not applying to any jobs, I'm going to have lost wages for 5 years, like, screw this.
Right.
You have to show that you are actively trying to apply for jobs regularly in the same field or position, like same level. So you don't have to like downgrade and go to a worse job.
Right.
You have to get a job on the same level that you would have. So as long as you can show that, and I've had clients that had really, really great high-paying jobs, and those are really hard to get, right? So sometimes it'll be a year or two of applying to like executive jobs, a year or two of applying to that before you
Right.
can really get a job like that.
That can be significant. Yeah.
That's past and future lost wages. So if you're making 200K a year and you can't find a job for a year, and
Right,
a year
right.
down the line we're bringing this lawsuit, and you can show that you've been regularly applying, we're going to ask not only for the 200K in back past wages, but we're going to probably ask for a year in future past wages and say that most likely it's going to at least take another year or 3 years to find a job. Now, if there are mental or emotional issues at play, which oftentimes, especially like really traumatic cases like sex harassment or like really bad retaliation cases when someone, utilizes their rights or complains about someone harassing them and then is fired, a lot of times that will cause a lot of psychological issues. They'll get treatment and sometimes they can't work. So you're entitled to the lost wages for however long you can't work as well.
Right.
And then you have the non-economic damages. So what is the value of your emotional treatment and the emotional cost that this has had on you? And that we look at, like, has the person received therapy? And sometimes we have clients that go to a new job, but they're so traumatized by what happened in their old job that they can't work for something. And they're continuing like treatment and trauma therapy. I have a client right now, and this individual was sexually harassed for years and nothing was done, and this person was humiliated, and this person is really, really struggling to like do well in their current job, and they have to take time off and work a part-time schedule, and we're going to be claiming all of that for lost wages because it's
Right.
not their fault, they can't work. And we have doctor's appointments, doctor's notes that prove and show by the therapist notes that this person is suffering because of the trauma they suffered in their prior position. So all of that could be attributable to that. And then you have punitive damages, right? If the harassment or the behavior is so terrible, we always claim that we could get punitive damages as well.
Is it still the same? You still have to show like malicious oppressiveness or fraud and stuff like that?
Well, it has to just be, malicious or
oppressive, fraudulent, yeah.
But a lot of times, especially when you have sex harassment or something where like the supervisor is kind of hiding what they're doing, a lot of times it's not that hard to argue punitive damages.
Yeah, it makes sense. I can see.
At least in my case, I don't take BS cases. I don't take like, I really want to fight for people, so
sure,
take the good ones. So usually punitive damages are not hard to argue on our cases, but if it's a smaller end cases that maybe don't have as much emotional distress, it'd be a little bit harder to argue.
Oh, okay. So obviously with any case, it's kind of fact, but fact sensitive.
And I guess if you lose like benefits or pension, that it's kind of harder to prove, but sometimes you can include that in your damages as well.
Okay. The other thing that it just came about because of the discussion we were having about employees being sort of hesitant to, go against their employer for various reasons. Is there like, I don't even know if this is possible, but is there like a way that they can like seal that thing? Like, let's say they file, right? Let's say the employee, let's say like Omidra Jolly files against, X, and then, the case resolves, and I just, I don't want everybody to know that I sued like whatever, because it's going to impact me in my community. So I don't know, can I like seal it later, or can I even like file as a doe or something?
Yeah, you can file as a doe.
Okay.
There are strict requirements to that, but I have seen it done. I haven't done it personally myself, but I have done, and I've defended cases with doe plaintiffs.
Okay. I mean, I think specifically probably when it comes to like sex harassment cases and stuff like that, maybe somebody would not want to obviously put their name out there. Okay, we're at about 45 minutes. This is all, wow, it was a lot of information. I certainly learned a lot myself.
Law is very overbearing. There's a lot
Yeah,
to it. After almost a decade of practice, I still am always learning something new, which I love. Honestly.
yeah, that's a good thing about it, right? It's like, you just never get bored. At
Yeah.
least that's how I am. One other thing for our audience and viewers, do you mind, or how can they reach you? Like, what's the best way if somebody wants to reach out? They have a question, or I don't know, family member or themselves. How can they reach you?
Yeah. So my email address. Can I give my email address on here?
Yeah, you can. Yeah.
So my email address is probably the best way to reach me. I usually will respond to emails starting anywhere from 3 in the morning.
Oh yeah, I know about that. I see that like 3 o'clock. I don't know, coffee in hand or whatever.
3:30 a.m. is my
Grinding
normal wake-up
away.
time. So
Yes.
make sure your phone's on silent if you ever email me. But my email address is Mila, so that's MILA at getgomez, GETGOMEZ.com.
Excellent. Well, there we have it. Mila, thanks for your time.
Thank you.
It's been great. Absolutely enjoyed talking to you, and I know there's going to be great information. This should be available actually on all 3 platforms. So, and those platforms are Facebook, LinkedIn, and YouTube. So we'll get it going on there. And yeah, so thank you so much again. And until next time, see you soon.
Thank you.
All right.
Bye.
Thanks. Bye.
Bye.